Good morning to those from the West Coast, good noon or whatever it's proper to call it in English in the East Coast, and good evening from us, Professor Weill and myself here in Israel. It's wonderful to resume our webinar series and to have the resumption of the webinar series featuring Professor Rivka Weill. I think quite a number of you are veterans. Some have called me to indicate how sorry they are that something came up or there was a conflict in schedule once we announced it and they couldn't join us, but they are looking forward to seeing the recording once we post it. Professor Weill, one can say, is not only a great speaker and a great scholar, but is back on the basis of popular demand. She has been with us a number of times with great reactions, and it's been wonderful to listen to her explaining complex issues in a very accessible and clear way. So Professor Weill is a law professor at Rothman University and then formerly the IDC, the interdisciplinary, so fast we forget, the interdisciplinary,
Interdisciplinary Center.
Yes, but the D.
Yeah, Interdisciplinary Center.
Okay, and an internationally renowned expert on constitutional law, teaching at various universities around the world and publishing in a variety of highly regarded professional publications. And the topic that she has improved on my suggestion is, if I can only open it, I don't want to make a mistake as I did with IDC, Israel's counter-constitutional revolution, where does it stand and where is it going? So the Israel's counter-constitutional revolution is Professor Weill's catchy label to what so many are calling by different names. The proponents from the government are calling it merely the judicial reform, a necessary and timely, urgent judicial reform. So urgent that it should take precedence over everything else that the country faces. The less enthusiastic individuals and groups that are watching, represented by hundreds of thousands who are marching in the streets in an unprecedented fashion in Israel's history. And I'm saying unprecedented because everybody agrees that nothing like that has happened in Israel's history since its inception in 1948. So they call it by different names, such as the Judicial Upheaval, and Hamapicha Mishtarit, the governmental overturn, and other names. I think Professor Weill's label is intriguing, the counter-constitutional revolution. So we will listen to Professor Weill introduce the topic and give us a sense, and many here are regularly following the events in Israel. So she will provide us with both a sense of what it is about, but more, where are we standing right now, literally right now, and where will all of this possibly go? And then use the chat, ask your questions, make your comments, and we'll try to cover as many as we can before we say farewell. But before I turn it to Professor Weill, we are resuming the series. So on August 8th, namely 2 weeks from now, we will be holding our second webinar with Professor Yofi Tirosh, who is one of the leaders, foremost activists in the area of gender equality. And she too spoke once in our webinar series. And she will be speaking on the judicial overall in Israel, the gender equality perspective. So anyone interested in either the judicial overall, as she prefers to call it, or the feminist gender equality perspective, join us. We'll be sending out the invitation soon on August 8th, Tuesday, at the same time, 7 p.m. Israel, noon New York, and 9 a.m. California. And the microphone is yours.
It's a pleasure to be here, Rabbi Regev. I thank you very much for the opportunity to have this discussion with you. This is a grave moment in Israel's history. Anyone who is following the news would be startled by the narrative used by both sides to the debate. We are on the eve of Tisha B'Av, the day that commemorates the destruction of the first and the second temple in Israel, and people are using the same words to describe what is happening now on the grounds in Israel. People are talking about the destruction of the third temple as a metaphor, the destruction of the social fabric of the Israeli state. And the metaphors are not just about, and this is enough, but it's not just about the destruction of the temple. Doctors who have suggested that they should strike have suggested that they are not going to serve under a regime that is similar to 1933. We have military personnel who have announced that they are going to stop volunteering to the Israeli reserve. So the opposition is very strong in Israel to the current agenda of the hardcore right-wing government in Israel. On the other hand, from the government's perspective, the narrative is also harsh. In recent days, we are hearing language such as a military coup to describe the fact that there are many who oppose continuing to volunteer to the army if some of the proposals for reform or for a constitutional counter-revolution, some of those proposals are passed. So the situation is very, very grave. So what I want to do today is actually try to explain the uniqueness of the constitutional moment Israel is currently facing. And I'm going to also focus on the particular item on the agenda, the idea that actually the government will curtail the court's power to review the reasonableness of government action, of ministers' action. Why is the government so adamant about passing this reform? Why is the opposition so grave to this reform? So there are a lot of topics for us to consider. And I'm sure that you may have more issues that you would want to discuss, so I will obviously be open to discuss them during the Q&A. So we are at a very unique moment in Israel's history. We have a hardcore right-wing government that is unique in the sense that Israel has actually undergone 5 election cycles in a 4-year period. Netanyahu, who faces criminal accusations, was facing a criminal trial on accusations of fraud, breach of trust, corruption, bribery, is actually found it very hard to form a government. Around half of the members of the Knesset boycotted Netanyahu and refused to sit in a government with Netanyahu. As a result of that, he actually formed a coalition with very extreme people within the Knesset, and particularly Itamar Ben-Gvir, who is the head of the police, the head of internal security, a person that Netanyahu did not want to be found in one picture with before elections. And in the coalition agreements, the coalition agreements require the government to pursue a constitutional revolution. The government at first tried to advance a comprehensive revolution all at once. And when it faced very first opposition, it actually backed down, and it is now trying to pass the revolution in a piecemeal way, but it is clear that one step will lead to the next one. Now, if you think about a particular enemy, a particular nemesis that the government is trying to attack, it's actually very particular or very peculiar that enemy is found in the figure of the former president of the Israeli Supreme Court, President Aaron Barak. Now, what is striking is not only that the so-called nemesis is a former president of the Israeli Supreme Court, but that he retired in 2006, so many years have passed since he left a position of power. Now, Barak was, during Barak's time on the court, he was very focused on building judicial power. He sat 28 years on the Israeli Supreme Court, 11 years as the president of the court. And over the years, he actually established in a gradual way many judicial tools that would enable the court to supervise the government and the Knesset, Israel's legislature, within a very weak separation of powers structure. So the government is aiming at dismantling the legacy of President Barak. Now, at first, the government attempted to do it in a way that I would frame it as the LIFO method in accounting. That means last in, first out. So the government actually focused on the last items on Barak's agenda before leaving the court. The government focused on actually weakening the power of the Supreme Court to review the constitutionality of statutes, to review the constitutionality of basic laws that are treated in Israel as Israel's formal Supreme Constitution. And the government also wanted that when the court exercises a judicial review over primary legislation, the court would be able to do so based on explicit constitutional rights alone. Now, the most important implicit constitutional right is the right to equality. So what the government is actually aiming is to allow itself to discriminate and not without having to face judicial review over the constitutionality of statutes that discriminate people. Now, in light of the intense opposition internally in the Israeli society, in light of international condemnation, the government actually stepped down, stopped pursuing the reform in a unilateral way, and agreed to negotiate with the opposition, with the major political parties in the opposition, and in the president's chamber, in Isaac Herzog chambers. The negotiations took place for a while, but eventually they failed because the government didn't actually abide by its commitment to elect its representative to the Judicial Selection Committee, the committee that is in charge of appointing and removing and promoting judges in Israel. And when that occurred, the opposition actually decided to leave the talks at the president's chamber. Since then, the government did elect its representative to the Judicial Selection Committee, but both sides now agree that they are not back to the president's chambers for further discussions and further compromise, at least not until we hear new news or until they decide otherwise, because we know that tonight maybe Netanyahu, Prime Minister Netanyahu, will give an announcement. So who knows? Everything is very fluid. Things are changing as we talk. In any case, the government decided now to act in a unilateral way. And this time it is pursuing what I would term the FIFO method, the first in, first out method in terms of accounting. And the idea here is that when President Barak was appointed to the court, one of the first moves he conducted was actually to develop the reasonableness doctrine as a tool to supervise government action. So in 1980, in the famous Yellow Pages decision, President Aaron Barak states that actually every executive decision must be reasonable, and if it is not reasonable, then the court can intervene and abolish that decision. So what is reasonableness? And I'm going to give you a definition, but some of you are not going to recognize that this is a definition, okay? The reasonableness doctrine means that the decision maker must take into account all relevant considerations and grant all relevant considerations proper weight. Now, if you ask me, what are the proper considerations? If you ask me what should be the proper weight to the different considerations, there is no clear answer. It depends on context. It depends on the discretion, first of all, of the decision maker, but second of all, of the court that actually reviews the executive decision. So this was a major development in Israeli constitutional law. Actually, at the time, it was mainly administrative law. We did not yet operate under the idea that Israel has a supreme formal constitution. And the reasonableness doctrine requires only that executive action, not legislative action, be reasonable. Okay, now, why does the government want to tackle the reasonableness doctrine? Why is it so important for it? And why does it assume that it is worth the price that we are currently seeing that it is going to pay if it pursues with its agenda? So from the government's perspective, it is about to pass a constitutional amendment to Israel's basic laws. It is going to amend Section 15 of Basic Law, the judiciary, and state that the Israeli Supreme Court cannot review the reasonableness of government decisions. It cannot review the reasonableness of ministers' decisions, and that includes also decisions regarding appointments. And that also includes decisions not to decide, okay, to refrain from deciding. Okay, now from the government's perspective, if it tackles first the reasonableness doctrine, this is the easiest way, both from a political perspective and from a legal perspective. From a political perspective, the reasonableness doctrine only restricts government action or executive action. The legislature does not have to act in a reasonable way. More than that, the idea behind the reasonableness doctrine is that the court is actually enhancing the power of the legislature vis-a-vis the government. The idea is that the court is stating that the decision of the government is unreasonable, and therefore we think that the legislature never intended the executive, the government, to enjoy such discretion. So the court is actually inviting the legislature to respond if it is not in agreement with the court. And the legislature may undo the judicial decision. And if you remember that Israel is a parliamentary system, we do not elect a separate executive. The same majority controls both the government and the legislature. Then supposedly, if the government does not agree with a judicial decision that a particular decision was unreasonable, all that the government has to do is pass a statute that and the statute will undo the judicial decision. So from a political perspective, if the government is saying, and through its action in the legislature, if the government is stating, we don't want want this protection of the court. We actually, at this time, in our heart, in our capacity as a legislative body, we state, yeah, we are willing to allow the government to be unreasonable. We don't care. The government may be unreasonable. Then so be it. So this is the political point. Now, from a legal perspective, you have to understand that the development of the reasonableness doctrine is a common law development. Now, Israel is a mixed system. It has heritage both from civil law systems because of the Ottoman period. It has also roots from the common law because of the British Mandate period, but it is predominantly a common law system. Now, as a common law system, the courts are empowered to develop common law doctrines, and the entire administrative law in Israel is common law made. In other words, the courts develop the doctrines to intervene in executive discretion, but under the common law, if the legislature thinks otherwise, the legislature may explicitly state otherwise. So in light of an explicit statute, the common law would back off. So from a legal perspective, it is easy for the government to undo this common law development that is not based in a statutory authorization, and it is not based in an explicit constitutional provision. The whole idea that the executive should act with reasonableness was developed by the courts alone. Now, in addition to that, the government is amending basic law, the judiciary, which, as I have said before, is part of Israel's former Supreme Constitution. The only thing is that Israel has a flexible constitution. It is mostly not entrenched. In the case of basic law, the judiciary, by a 2-to-1 majority, the Knesset may amend the basic law, the judiciary, that, by the way, also protects the independence of the courts. This is why there is so much fear within the opposition that actually the next move of the government is actually would be to reform the Judicial Selection Committee, would be to reform the way we appoint and remove judges, and would compromise or even totally annihilate judicial independence in Israel. So from the government's perspective, politically, legally, it is rather easy to undo the reasonableness doctrine. In addition to that, the government believes that it will actually reap many benefits if it abolishes the reasonableness doctrine. And what are the benefits? So you have to understand that President Barak's first move was to develop the reasonableness doctrine as an independent doctrine for judicial intervention in executive decisions. But that paved the way to the next major revolution, and that is the justiciability revolution and the standing revolution in 1988 in the Ressler decision, the idea that any matter may actually be reviewed by the court. Any matter is justiciable, that the court cannot actually think of a matter that would not be justiciable, that the court cannot state whether it is legal or illegal. The court did leave open a room that may be based on the fear of losing public confidence in the judiciary. The court would decide that something is non-justiciable. But in general, all topics in Israel are justiciable, including war and peace issues. And that does not mean that the court intervenes. It means that the court would deny the petition based on the fact that the decision of the government is reasonable, okay? And not based on the fact that it is not justiciable. So from the government's perspective, if we shrink the reasonableness doctrine, right? They want to shrink the reasonableness doctrine. They don't want to abolish it. And they want to immunize government decisions, minister decisions, but not the administrative branch decisions more generally. So from the government's perspective, if it diminishes the power of the court to review government decisions, then maybe it will also shrink the idea of justiciability. Maybe the court will find that some issues are non-justiciable because it does not have a standard to review the decision of the government. Until now, the court always had its standard to review government decisions. If there was no statute, if there was no constitutional provision, the court could always argue that the decision was reasonable, unreasonable. Now there is no all-encompassing doctrine such as reasonableness. So this is a major aim of the government. By the way, I would just mention that someone has the microphone open. Maybe Rabbi Regev, maybe you have it open. We hear some noises. I'm not sure if it comes from my microphone or from others' microphone. In any case, but the government has many more aims at stake. So the reasonableness doctrine has been used primarily to protect against extreme unreasonable appointments and removal of people from the executive branch. Okay. So let me explain that. In the US, you would think, this is normal. Why do we hold elections? We hold elections because we want the president to enjoy executive power, to appoint a large segment of the civil service, a large segment of the executive branch. There is a thick layer of political appointees. And this is part of the nature of a presidential system. But the Israeli system is different. We are a parliamentary system. We don't have a true separation between the executive and the legislative branches. The same majority controls the legislature and the executive. So we get this separation between the two branches to a larger extent via the civil service. We have a thin layer of political appointees in the executive branch, and we rely on a professional bureaucracy to keep some kind of checks and balances vis-a-vis the government. Now, the court has used the reasonableness doctrine to actually intervene in cases where it's suspected that actually there were ill motivations for the decision to appoint or remove someone from office. You have to understand that in Israel, the administrative review is not like in a regular adversarial system. The court does not allow witnesses. It does not allow for questioning witnesses. There is no cross-examination. The entire discussion is conducted via affidavits alone. So the entire process is based on affidavits alone. So if the court suspects that there is some kind of an ill motivation, some kind of corruption in the appointment or removal of a person, then the court, instead of basing the decision on ill motives, it uses the unreasonableness doctrine. And this is exactly what the government is trying to take away from the court. So we are a small country. Israel has a population of around 10 million people. At the territorial size of New Jersey, corruption may become much more prevalent once reasonableness is removed. So this is where, again, we are so different from the US. And the Federalist Papers state the size of the country as an important constitutional element in the protection of liberty. And Israel does not have it. It has the reasonableness shield. And this is not a theoretical discussion. There are actually particular positions. There are actually particular people that the government has in mind when it is abolishing the reasonableness doctrine. So let's talk about the Attorney General of the State of Israel. So we have a very brave woman who is actually currently in the position as the Attorney General of the State of Israel. And she is facing severe, harsh treatment from the government. As the government was promoting the abolishment, a shrinking of the reasonableness doctrine, at the same time it summoned Gali Baharav Miara, the Attorney General of the state, to a government meeting. And for almost 4 hours, the government was grilling the Attorney General of the State of Israel regarding the Attorney General office policy towards those who demonstrate against the government? Why aren't there more criminal cases opened against demonstrators for actually demonstrating against the government? The government is claiming that the Attorney General's office used much more brutality or used much more prosecutorial discretion to actually charge people during the disengagement from Gaza in 2005. So it is arguing that the Attorney General's office is colored in political colors. It is actually serving the left center of Israel, and it is against the right wing government. And it actually, the government required the Attorney General to come up with a policy of actually prosecuting those who protest against the government. In addition to that, the government actually wants the Attorney General's office to use its criminal prosecutorial discretion to actually charge people who are calling to refuse to volunteer to the reserves in Israel. They see it as actually amounting to a criminal offense, even amounting to some kind of a treason, and it wants a policy that will actually allow much more prosecutions of the opposition to the constitutional reform in Israel. Now, I said that the idea that they want to fire and appoint some people is not theoretical. So the Attorney General of the State of Israel is supposed to serve for 6 years. She was appointed in 2022. But the government may remove the Attorney General if it decides that it cannot work with the Attorney General, that actually there is no good working relationship between the parties. So it seems that the government is already establishing the grounds for such removal. Some ministers have openly said that they want the removal of the Attorney General. Now, the Attorney General of the State of Israel is a very different position than the US. You remember the stories in the US, definitely during President Trump time, that actually, you know, we can replace an Attorney General, you know, to have an Attorney General of our liking. It's a political appointee. But the Attorney General of the State of Israel, it's an independent office. It has three, it actually is in charge of three important roles. The first, it is the Attorney General is the head of the prosecutorial office in Israel. The second is the Attorney General advises the government about the legality of its actions. And the third is that the Attorney General's office represents the government in court. Now, politicizing the Attorney General's office is extremely dangerous, especially when there is a criminal ongoing trial against the Prime Minister of Israel. So we are very worried about what will happen with the Attorney General of the State of Israel once reasonableness is removed and once the major way for the court to intervene in removal of executive officers was through the reasonableness doctrine. But in addition to that, the chief of the police is about to retire. Itamar Ben-Gvir, that I've already mentioned, who actually has criminal records regarding issues that are related to racism, to terrorism, is the head, is the minister of the police, is the minister of internal security. He wants to appoint his chief of staff free from the reasonableness doctrine. He wants a police that would be able to act in a less reasonable way, especially when it comes to the protest against the constitutional revolution. In addition to that, you know that I'm sure that you are following also Israel's economy. The dollar is up, the shekel, the Israeli NIS is down as a result of the upheaval in Israel. And the governor of the Central Bank of Israel is about to finish to serve his term in office. The government would appoint the next governor of the Israeli Central Bank. and if it can appoint this position free from the reasonableness doctrine, then we should be worried who will actually fulfill that role. But these are just examples. Okay, now I'm sure that for some of you, it seems still a little bit peculiar. Why would reasonableness be so important? We know that also in the US we have a reasonableness doctrine, but we also have a deference doctrine. The courts would warn themselves that they should not intervene, but only as a last resort. They actually understand that the executive branch is a professional branch, that the administrative bodies are professional, so there is a deference doctrine, and the court intervenes only in extreme cases. And what I want to explain to you, and this is actually based on an article that I recently published that is titled "On the Nexus Between the Strengths of Separation of Powers and the Strengths of the Judiciary." What I want to explain to you is that actually there is an inverse relationship between the strengths of separation of powers in a given country and the strengths of the judiciary. We typically think about the judiciary as part of the separation of powers. So the very title of my article seems weird. Why would I position the judiciary against the separation of powers, as reacting to separation of powers? It is part of separation of powers. But my argument is that both from a normative perspective, but also on an empirical basis, we find that the judiciary does react to the strengths of separation of powers between the other branches of government. In other words, when you have a strong separation of power system, as you do in the US, right? You have a presidential system, you have a federal system in which there's competition over power between the states and the federal government. You have a bicameral legislature, so you have, again, competition over power between the two houses of the legislature. You have an entrenched, rigid Supreme Constitution. When you have all these mechanisms at play, then the courts understand that they can develop doctrines that will reflect the fact that there is a strong separation of power system at place. So the courts, to begin with, develop common law doctrines, such as standing, such as justiciability, such as reasonableness, that carve a very small role to the judicial branch. They know, the courts understand that they need to intervene only as a last resort. In Israel, we have none of that. It's a weak separation of power system in the sense that it's a parliamentary system. We don't have an elected executive branch. We don't have a bicameral system. We have a unicameral system. We have only one house that serves as the Israeli legislature, the Knesset. We don't have a federal system. We are a tiny country the size of New Jersey. We don't have an entrenched, rigid constitution that is hard to amend. The Knesset amends the constitution, has the power to amend the constitution. The Knesset is Israel's constituent assembly, and it can amend the constitution as it likes, and it does so repeatedly. So when you have such weak separation of power structure, the court responds to the weakness of the separation of powers structure. So the court asserts, argues that it has more power. It develops strong standing, a very wide standing doctrine. Anyone can bring an issue before the court. It develops a broad justiciability doctrine. Everything is justiciable. We can decide about everything. It develops a broad reasonableness doctrine. All executive decisions should be reasonable, etc., etc. So the court creates a narrative of strong intervention, of broad intervention. But don't be confused. There is a major discrepancy. There is a major gap between what the court asserts and what the courts actually do. And why is that so? Because in a weak separation of power system, the court understands that if it intervenes too often, then because it's a weak separation of power system, the political branches will retaliate So actually, the fact that we have a broad reasonableness doctrine, the fact that the court asserts power does not mean that the court intervenes more often. And I showed that also in my article, and whoever is interested can look it up. So why can't Israelis actually reach a compromise? And with that, I will end and open the floor to Q&A, because there are so many other issues we can discuss, but also this particular topic we can develop. Supposedly, there are many ideas that were proposed as a compromise. People have suggested, including the President Chambers, that maybe only government's decisions will be immunized from judicial intervention based on reasonableness, but not ministers' decisions. There are ideas that appointments would be carved out and would be subject to the reasonableness doctrine to prevent corruption. There are ideas that if the appointment is done with the Knesset consent, so there is an input from the legislature, then only then there will be the decision would be immunized from judicial intervention, so forth. So there are many ideas in the air, but it does not seem so far that a compromise would be reached. And the reason is that this is in a way a test case for both parties. And it's a test case in a very worrisome way, in a very frightening way. From the government's perspective, this is like, you know, this is only a balloon. This is only the first step. The government understands that the court has many other tools to intervene and would likely develop, already has at its arsenal, doctrines to compensate for the removal of the reasonableness doctrine. But once it shows that it can do so and survive, and once it does so and actually proves to the country that, you know, this is not a dictatorial state yet, then supposedly, you know, the opposition is crying wolf, 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 and we should discount the threats of that, you know, the government agenda would lead to a dictatorial state, and this will maybe open the door to the government to pursue further reforms. From the opposition side, the opposition understands very clearly that this is just a first step, and that democracy doesn't lose its nature overnight. It's a gradual process. And it feels that once the government, you know, despite the first opposition, will actually use its force and enact the reform, that would be a point of no return. It will show that the government is actually adamant about pursuing other agendas that are even much more serious and much more threatening. And the most serious threat of all is to the independence of the courts. And that would actually be a point of no return to Israel's democracy. So the situation is grave, and we are reaching a point of no return. And what I've tried to do today is actually give you a sense of the intensity of the struggle on the grounds, and to explain to you why the government actually backtracked and decided to actually pursue reasonableness first as a test case for its ability to pursue other even more dangerous items on its agenda. And to explain to you, I'm not trying to mitigate in any way the seriousness of reasonableness. I am very worried about the reasonableness doctrine because of the motives of the government, because of the will of the government to be free from supervision regarding corruption. And that is very serious. And not just corruption, but the idea that the rule of law should not matter, that the Attorney General's office should be weakened. All these are very frightening agendas that are hidden behind the idea of abolishment of reasonableness. But reasonableness itself is not the big issue because the court has other tools to compensate for the reasonableness doctrine. I expect the court to primarily develop proportionality as a substitute for reasonableness. In other words, the court would use the new language instead of stating this is unreasonable, the court would state this is not proportional. And it would use not proportional, not just to protect constitutional rights, but it would use proportionality to protect also the rule of law, the integrity of the government, etc. But the fact that the government would unilaterally, despite fierce internal opposition and international condemnation, go ahead with the reform, that can prove to be a turning point in the story over in the entire ordeal. It is a fight over the soul of the Israeli state as Jewish and democratic. So thank you so much for listening to me, and I'm very much open to the Q&A. Rabbi Regev, I can't hear you.
Yeah. I needed to unmute myself. Thank you, Professor Weill. As I said, extremely complex issues. I know that they left some of you baffled, but don't worry, you're in good company. I think that many Israelis on both sides of the issue have a sense of what's at stake, and they understand that it goes to the heart of the Israeli democratic character, though the details somehow are lost on some people who do not have the pleasure of listening to Professor Weill and having an exposition of, what's the context, what's behind it, where does it come from? And so before I see if there are any questions or comments from you, let me just say, you heard Professor Weill mention the grilling of the Attorney General just recently in a multi-hour government meeting, which was extremely degrading, ugly, but to illustrate the poisonous nature of the refusal to accept the Attorney General as the person in Israel's judicial and legal history who is providing the government with the word of the law that is binding on the government, short of contrary court ruling. I can just refer to what Minister Dudi Amsalem said in an open meeting at the Knesset yesterday. Now, Minister Amsalem, you may recall from other contexts, when he was chair of the Knesset Domestic Affairs Committee, he was instrumental in dismantling the Kotel Agreement and degrading Reform Judaism. And clearly for him, Reform Judaism is a generic name. It's not as if he intended to single out reform compared to conservative. So that's the person. And yesterday, now in his capacity, interestingly, as minister in the Justice Ministry. So he's not the Minister of Justice, but he was appointed minister in the Justice Ministry with variety of authorities. One of them is overseeing the governmental company authority, and there is a parallel, shameful assault that he has been launching against the, again, female appointee who heads the government company's authority. Professor Weill may want to say a word or two about that as well, but here is what he said at an open meeting session of the Knesset yesterday, in his capacity as both minister in the Justice Ministry and the minister who serves as the liaison between the government and the Knesset. Quote, "The Attorney General is the most dangerous person in the state of Israel today until we remove her from there. And we should have removed her yesterday already. She constitutes a substantive threat to the stability of the democratic state of Israel." it can't really get more confrontational and uglier than that. To just recap what and add one minor dimension to what Professor Weill was saying, because there are so many items on the agenda, and the concern of the protest movement, which is fueled often by speakers from Poland and Hungary, is that Israel will be facing what the Poles and the Hungarians did not realize in time, and that is the threat of a piecemeal dismantling of a democracy. Namely, realizing that the one package assault just didn't work out, what we are now seeing is, all right, on Monday, it's just a reasonable doctrine. And what is the reasonable doctrine? You know, it's something that can be dispensed with. It's a minor issue. It didn't exist some decades ago, etc. And what you hear are already contradictions between Prime Minister Netanyahu committing supposedly to President Biden that that's the only thing that's going to move forward. Everything else is going to be done only on the basis of wide consent, with Netanyahu's partners in Israel saying nothing of the sort. This is just an appetizer, as Minister Ben-Gvir recently said. We want the full package. We want the full meal. So just to give you a sense and a sort of a sense of relevance of the issue at hand, because Professor Weill mentioned that the next on the agenda is the appointment of Supreme Court judges. In June, and we posted something about it in the Chidush's Facebook page, and we have written about it. In June, there was a leak from a deliberation at the cabinet in which the Minister of Justice, Yariv Levin, who is responsible for the process, was saying Arabs are trying to move into Jewish neighborhoods. Jews don't want to live next to Arabs. They are moving out. We need to appoint judges to the Supreme Court who understand this. Just hear what that says and what it says to those who have lived through or whose parents lived through the period in which Jews were not welcome in Gentile, in certain neighborhoods, in certain country clubs. For Minister Levin, this is one key example of why we need to remove judges from the Supreme Court and appoint others who are on the same page as we are. We need judges who understand that Arabs should not be allowed to move into Jewish neighborhoods. So again, this isn't, my interpretation. These are explicit quotes that we translated into English from Minister Levin's own argument or claim at the cabinet meeting. All right, let's look at the chat.
Rabbi Regev, if I may just
of course
a few things. So you mentioned the confrontation between Minister Dudi Amsallem and the head of the corporate authority, which is another independent branch in Israel. And what you have to understand is that the head of the corporate authority actually is a very important position. That the government wants to appoint many directors to government companies, which means companies that are that has a substantial ownership of at least 50% by the government, and the director positions, the managerial positions are very lucrative, and currently it is done by a professional process, and this is one of the reasons that there is so much tension between the Minister Amsalem and the head of the corporate authority in Israel. But one more thing that I want to emphasize is about the judicial independence that Rabbi Regev has discussed. Regardless of your political opinions, you should oppose an attempt by the government to actually be in charge of appointment, removal, or promotion of judges. And here again, supposedly, if you compare to the US, it seems, why would we oppose that? Isn't part of the executive power, or at least the elected branches, to appoint judges? Why should we be worried about it? And here you have to understand that in Israel, again, first of all, we are a tiny country, so corruption is more, it's easier to spread. But in addition to that, what is happening in Israel, that there are no proper checks and balances against removal from office. It is not like only during high crimes and misdemeanor you can remove from office, and only under a very arduous process that requires the two houses of the legislature and the chief of the justice presiding over the process, a full impeachment process. In Israel, it is entrusted to the Judicial Selection Committee to both appoint and remove. To remove, you can do it with a supermajority of members of the committee. But if we allow the politicians to handle the process, then judges would be afraid that they are going to be removed, and that would actually mean the loss of judicial independence in Israel. And I want to emphasize one more thing, that in Israel, the appointment of judges is not done like in the US, by the full, by some kind of a cooperation, let's say, between the president and the full Senate, but rather we have a judicial selection committee in which each of the members must exercise independent judgment. So if we entrust a majority on the judicial selection committee, which is composed of 9 members, if we entrust a majority to appoint, remove, promote judges, or even entrust it to a supermajority, if those members are politicians, then that would mean the end of judicial independence in Israel. It's the sole discretion of a few people in Israel that would actually control the entire judicial system in Israel, and that would be a catastrophe. That would be the end of Israel's democracy. But I'm willing to elaborate on that more in the Q&A.
Okay, so we'll start with 2 questions, and Eva asked, so what can American Jewry do about it? And I'll leave that to the end, and I'll say something about it unless, or in addition to whatever Professor Weill may want to say. But just to clarify, so when Professor Weill speaks of the reasonableness doctrine, I think that it should be understood, A, that the court is not really speaking about reasonableness, but intervention in the case of extreme unreasonableness. Namely, it is not when the court feels that it would have made a different decision than the executive did, but and I don't remember the statistics, but the instances in which the court intervened on the basis specifically of the reasonableness doctrine are relatively few. But Professor Weill may have a different take on that. So the 2 questions are, Judge Peter Buxbaum is asking, how does the reasonableness test compare with the American arbitrary, capricious, and unreasonable test in the states, or the new federal major question doctrine? Alan Warshaw asked, can you explain proportionality a little bit more? In certain US cases, that applies to the population, minorities, gender, etc. Can that apply more broader in Israel in lieu of reasonableness possibly being removed?
Okay, so there are many issues on the table. I will actually start with American Jewry, not just American Jewry, world Jewry. The Israeli Declaration of Independence was signed by representatives of both the Jewish Ishuv, but also the Zionist movement more generally. So there are two parents to the Israeli state. Representatives of those who were in Israel, who were part of the population building the state, but also representatives of the Jewish organizations, of the world Jewry more generally. Under Israeli law, the law of return is actually not just a regular statute, but it enjoys a constitutional status based on the fact that basic law, the nationality, basic law that actually declares Israel as the nation state of the Jewish people, actually in that basic law, that is a very contested basic law, we can also go into that, but in the basic law, there is an explicit statement about the law of return. So the idea is that actually there is a special relationship between the state and the world Jewry, and therefore I would say that it is my argument that world Jewry in general do have what to say in the discussion, and they should pronounce and be part of the debate over the nature of the Israeli state. And actually in many judicial decisions, the court has emphasized time and again that the fact that Israel is a sanctuary place for the Jewish people, and we've seen it materialize time and again throughout history, most recently regarding the war in Ukraine and Russia, where we have many people coming from Ukraine and Russia and find and actually decide to make Aliyah. So as I'm suggesting, you should take part in the discussion and pronounce your opinions, and it does have effect on the grounds. The court doesn't use only extreme unreasonableness standards. It's actually not arbitrary or capricious or only extreme unreasonableness. The court intervenes also in reasonableness more generally. Actually, when Barak developed the reasonableness doctrine in the Yellow Pages decision in 1980, what he did was develop it as an independent basis for intervention. Until 1980, the court many times stated that a decision was capricious, or a decision was arbitrary, or a decision was illegal, or what have you, and also unreasonable. In 1980, Barak stated, no, it can be unreasonable alone, and that would serve as a basis for intervention. Now, in 1980, Barak was careful, and he stated, I'm not sure, I'm not clear, maybe the standard should be only extreme unreasonableness. I don't know, I leave it open. Going forward, the court actually used reasonableness alone to intervene, even in government decisions. But when it comes to appointments, and when it comes to removal from office, the court does use the standard of extreme unreasonableness. So this is where it is true. Nonetheless, it is true that the reasonableness doctrine operates more in the margins. As I have suggested, in a weak separation of power system, you don't expect the courts to use too much power, because it should fear the retaliation of the political branches. So there is a large gap between the narrative and what happens on the grounds, but that's not how you measure the effect of a judicial doctrine, because we know that when you have the power of intervention, that affects the government position to begin with. And this is actually what the government is arguing. We are so afraid of judicial intervention that we are not making decisions. And I would argue, if you want to make a decision, you believe it is reasonable, make it, and let's see what the court decides. And that is not a reason to abolish reasonableness. But the effects of reasonableness is not just by how the court intervenes de facto, but that the threat of intervention prevents the government from pursuing certain agendas. If the agendas are unreasonable, we should be happy that the government is not pursuing them. But if they are reasonable, but the government is nonetheless afraid of judicial intervention, then you know what? Too bad for it. It should, if it believes that it is reasonable, it can pursue its agenda. If the court intervenes, the legislature may overrule the judicial decision. The major questions doctrine is, I haven't had the time to actually, I'm aware that the recent decisions in the US have focused on the major questions doctrine. Actually, the decisions are on my table, but I didn't get a chance to read them because of the current situation in Israel. But my sense is that the major questions doctrine is more about the idea of the non-delegation doctrine. It's about the idea that sometimes we need to make sure that actually the legislature authorized the executive branch to operate, and it is different from the reasonableness doctrine that actually does not focus on authorization, but focuses on the question, how do you use discretion? Which leads me to proportionality and how is it different from reasonableness. So first of all, if we look at the Canadian charter, right? So the Canadian charter in section 1 states reasonableness, not proportionality, and that actually was developed as a proportionality idea, right? But the idea of proportionality in Israel is a threefold idea, and it is actually based also on comparative law. It is true in Germany, in Canada, in other places. And the idea is as follows. There should be a rational connection, a rational nexus between means and ends. Okay, if there's no rationality, then it's not proportional. And the second test, and the three tests are cumulative. The second test is actually, it should be the least restrictive means of pursuing the agenda. And in constitutional rights context, it's the idea, if you can do something in a less infringing way on constitutional rights, you should use that means rather than the means you have chosen. Right? So it is the necessity test. Do you really need the means to achieve your goal, or can you use less offensive means to achieve your goals? And in the last test of proportionality, what we call proportionality stricto sensu, the idea is that we do some kind of a balancing test. We look at the benefits versus the costs of the government's policy. And the balancing test, the third test, reminds us of the reasonableness doctrine. Here, when you think about the cost and benefits, you can actually take into account what reasonableness actually does. You can ask yourself, okay, did we take into account all relevant considerations? Because all relevant considerations are part of a cost and benefit analysis. Did we give them proper weight? If we didn't give them proper weight, probably the costs are heavier than the benefits. So then the means are not proportional. So in other words, we can use proportionality to replace reasonableness, and we could use proportionality from a theoretical perspective, not just when it comes to constitutional rights, right? To think about is the means rational? If there's a rationality in government action, is the government action necessary? If the government action is justified from a cost-benefit analysis, we can ask all these questions, even if constitutional rights are not at stake. So from my perspective, a proportionality would replace reasonableness as a means to intervene in executive discretion.
Thank you, Professor Weill. We say in Hebrew, "Ein kamoch." It's a phrase. It's translated, "There is no one like you." I don't think it's the same thing translated into English, but Professor Weill is really unique in being able to decipher for us these complex issues and convey them to non-legal experts. I assume that some have gotten more than they bargained for in this session, but if you listened and if you will go back to the recording, I'm sure you'll be able to have a far better sense than the average colleague, friend, family member, etc., who is concerned about what's going on in Israel, but knows it only at the level of the headlines. So I will refer to Eva's question regarding American Jewry and go slightly beyond where Professor Weill left us, but let me just say once again, August 8th at 7 p.m., Alan, it's Tuesday, not Wednesday. Professor Yofi Tirosh will speak with us about the feminist perspective, the gender equality perspective of the judicial upheaval that's planned, unfolding, and much of it is already unfolding. And after that, we have not set out the exact date yet. We'll have Gilad Kariv speak with us about the political perspective of the current upheaval. I want to, before I respond to Eva, and to Richard Fulton, who asked, isn't it a dangerous thing to ask American Jewry to intervene? How do Israelis feel about it? So I want to thank JPLAN, the Jewish Pluralism Legal Action Network, Mark Enshen, David Light, and Judge Peter Buxbaum, co-chairs, have been with us to the Jewish, the Ruach Hidush, Rabbis and Cantors for Religious Freedom and Equality in Israel. And many of its members have been here, and I haven't noticed, but at least Rabbi Neil Gold from the Executive Committee. I want to acknowledge Steve Greenwald, past president of the American Association of Jewish Lawyers and Jurists, and I think currently vice president in charge of international affairs, our longtime friend and partner in these webinars and beyond. I want to end with the response. We need to understand that when you ask Israelis, do you want American Jewry to weigh in on security issues, to suggest where the borders should be drawn, what security measures should be taken, what risks Israel should be taking, the majority of Israeli Jews would say, no, keep out of it. It's our children, it's our blood, it's our lives that are on the line. On the other hand, repeatedly, as those who have been reading Chidush materials have seen, we sample the question, how do you relate to the fact that American Jewish leaders or diaspora Jewish leaders are pursuing engagement in matters pertaining to religious freedom and equality, such as freedom of marriage and eliminating the monopoly of the chief rabbinate? The majority of Israeli adult Jews are saying, bring it on. Again, the percentage is approximately 62, 65%, namely approximately 2/3. So the question is really what it is that you are asking about. What needs to be understood is that on this issue, namely the judicial reform, upheaval, however you want to call it, the majority of Israelis oppose all the specifics of the government package. This has been repeatedly ascertained by the Israel Democracy Institute and all the major television networks who have commissioned polls on this question. So regarding the specifics of should the Supreme Court judges be appointed by the politicians, and should the Supreme Court be blocked in its judicial review, etc., 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 the clear majority of Israeli of Israelis and of Israeli Jews come down on the side of the protest movement. And therefore, even though I've not seen a specific poll done on what do Israeli Jews say about American Jewish or world Jewish intervention on these issues, and I fully agree with Professor Weill as to the ideology behind it, the foundations of that relationship. What I'm saying is beyond that. What I'm saying is Israelis are eager for any partnership with anyone who can assist in countering what what Professor Weill titled as the counter-constitution revolution. And that is a fact. And it's ironic that the President of the United States has set himself further high on this ladder than the American Jewish leadership. It's ironic that the majority of Jewish established leaders are still sitting on the fence, and it's ironic, and from my perspective, wrong, that when they come down from the fence, what they're saying is, call off this plan, call off this threat. Let's go back to good old yesterday. You know what? It wasn't good old yesterday. And what we need is an alternative paradigm that we work on together, the overwhelming majority of Israeli Jews, and I am sure the overwhelming majority of American Jewish leadership, that wants Israel to be truly Jewish and democratic, as in not only safeguarding the constitutional elements of democracy, but also the foundations of religious freedom and pluralism and equality. We should not settle for just going back and withdrawing the current threat. And that is what Stanley Gold, our chair, and another friend who has joined us in moving in this direction, who is known to many of you, Rabbi David Saperstein, and others, and we and I are trying to do now. We are hoping to relaunch the outreach on the vision statement of Israel as a Jewish and democratic state, which sets out the parameters not of the resolution of the security or the Palestinian conflict, but on the domestic issues of being Jewish and democratic. And the uniqueness of this effort is, and I'm reminding to those who have forgotten or who have not heard about it, and you will soon hopefully hear about it. The uniqueness of that is that it is already supported by thousands of key leaders and activists from Orthodox, conservative, Reform, Reconstructionist, Renewal, unaffiliated, right-wingers, left-wingers, because it is not taking a position on the controversy between left and right. It is not a denominational push. It is going to the heart of what Israel is as a Jewish and democratic state. So this is a rather lengthy response to the question of, so where should American Jewry be? I'm telling you, Richard Fulton, Israelis have an open and welcoming door for American Jews and American Jewish leadership that would come down on the side of Israel as a Jewish and democratic state in the spirit of Israel's Declaration of Independence, ensuring freedom of religion and full social and political equality, regardless of gender, race, or religion. And I hope very much that some of you here are capable of doing that, that you will be constructively nudging your fellow leaders and your fellow activists to bring together a clearer, louder, and more assertive voice on the part of American Jewry that would go beyond just, can't you be nicer to each other? Can't you have a more constructive dialogue, reach a compromise and get us out of that loop? You know what? That's not the issue. All right. Yes.
Let me just add 2 points. Some people think that opposition to the current government's agenda is politically motivated in the narrow sense of right and left, or is politically motivated by the fact that the opposition does not accept the legitimacy of the government at place. So this is actually a protest against the Netanyahu government more generally, not specifically against its agenda. And I would want to argue that this is not the case. And I actually have research that I didn't publish yet, but I've examined also the platform, and not the platform, but actually the campaign of the Likud, the major component of this coalition. What was the campaign about? What were they talking about? What were they promising the public? And I can tell you from my research that actually the campaign did not include the judicial reform in the government terms or the counter-constitutional revolution. The opposite. Netanyahu, when asked, denied any will to actually revolutionize Israeli constitutional law. And he actually, a few days even before election, he came out with a campaign that actually marked this idea that he would be dangerous to Israel's democracy, that he would launch this kind of agendas that we are currently facing. So actually many Israelis feel that this government does not enjoy a mandate from the people at elections. It was not elected on a platform of constitutional reform. This came as a surprise to Israelis. And the opposition is to the agenda, not to the government. And the opposition to the agenda is because it will revolutionize Israel's nature as a Jewish and democratic state to the point that Israel would stop being a democratic country if the government actually achieves its goals. Now, in the beginning of the year, Mark was here. Mark is actually here. So Mark actually invited me to his congregation in Canada, and I was actually giving a lecture and explaining actually how the government's particular agendas would lead to the dismantling of the Jewish and democratic state, how each of the particular institutional reforms will actually lead to a redefinition of the identity of the state as Jewish and democratic. So the stakes are very high, not just in terms of the institutions, but in terms of the identity of the state as Jewish and democratic. And it's not just Jews and Arabs, it's also women's place in Israel that you would hear in 2 weeks' time, etc., etc. So these are grave times for Israel, and it goes beyond regular politics of left and right.
So right, and what can I say? Just what I said before to Professor Weill, Ein kamoch, there is no one like you. And I will be sending out not just the link to the recent article, but to the other article that Professor Weill alluded to, which is really enlightening and unique in the sense of explaining why is it, as Professor Weill said, why is it that we look at the American model where there is far less activism, so to speak. And there are other elements that people point out that, especially by the proponents of the reform, who say we are only following the American model. Why is it that the two countries that are both committed to democratic process have a different response and a different way of conducting the affairs and the recognizing the role of the Supreme Court. And here, Professor Weill's explanation putting the emphasis on the extent to which the respective countries, and actually Professor Weill is referring to other countries as well, and suggests that this is a criteria that could help us understand the different functions of the Supreme Courts in different countries. But the extent to which separation of powers is ensured in countries makes it possible for the Supreme Court in those countries to tone down its intervention, as opposed to the situation that we are facing in Israel, and Professor Weill described so beautifully. So understanding that is also a key, especially for our US friends who wonder, why is it the Supreme Court in Israel feels so so compelled to move beyond areas that in America are not necessarily taken for granted. Thank you all. I hope to see you all on July 8th. Thank you, Professor Weill, and follow the news and take an active role, educate yourself, reach out to friends, support Chidush. Shalom and Laila Tov.